The story of Graver Tank v. Linde Air Products, the case that clarified the doctrine of equivalence in the USA. 1.0. The Spark of Invention and the Shadow of Imitation. This was more than a dispute over welding flux. It was a struggle between literal words and inventive substance. Linde Air Products held a patent for an electric welding flux called union melt, claiming a composition that used alkaline earth metal silicate. Its product used magnesium and calcium silicates, both alkaline earth metals. Graver Tank introduced a competing flux, Lincoln-Weld 660. It worked the same way and produced the same weld quality, but used manganese silicate instead of magnesium silicate. Manganese is not an alkaline earth metal, so Graver argued its product stayed outside the literal wording of Linde's patent. The case reached the U.S. Supreme Court, confronting a core question. When does something that looks different in language become the same in function? 2.0. Words versus substance. Linde invoked the doctrine of equivalence, arguing that patents protect inventions, not just words. If an imitator makes a minor, insubstantial change while copying the core idea, it should still be infringement. The test. Does the accused product perform substantially the same function, in substantially the same way, to achieve substantially the same result? Graver defended using strict claim interpretation. Patent law requires inventors to particularly point out and distinctly claim their invention. What is not claimed belongs to the public. Allowing courts to stretch claim language, they argued, would turn a patent into a nose of wax, twisted to fit whatever the inventor later wished to cover. 3.0. Substance prevails. The Supreme Court's verdict. The court sided with Linde. Justice Jackson declared that minor, colorable changes cannot defeat patent protection. The court ruled that equivalence is a question of fact, based on purpose, properties, and interchangeability of materials. Chemists testified that manganese and magnesium silicates behaved similarly in welding flux. Prior patents even showed manganese silicate was known in the art. The court also noted that Graver's product showed signs of imitation, not innovation. The substitution was deemed insubstantial and thus infringing under the doctrine of equivalence. 4.0. The dissent's warning. Justice Black, joined by Justice Douglas, issued a strong dissent. He argued that expanding patent scope beyond claim wording undermines legal certainty and bypasses Congress's remedy of patent reissue for correcting claim errors. Justice Douglas added that Linde had originally disclosed manganese silicate but excluded it from the claims, thus dedicating it to the public. But including it through equivalence, the court was granting a monopoly over something not patented at all. The dissent feared the ruling would create uncertainty and force companies to guess what courts might later consider equivalent. 5.0. Legacy and key takeaway. Graver Tank v. Linde Air Products firmly established the doctrine of equivalence as a guard against trivial modifications that seek to evade patent protection. It ensures that patents protect the substance of an invention, not merely its literal wording. The lesson: in patent law, substance can triumph over form. If the invention is copied in essence, even without literal duplication, it may still be infringement. Thank you for listening.